both in the downtown Superior Court. Mr. Nagley, I did receive a recommendation from the state. Did you receive that recommendation?
I did, Your Honor.
Okay. Did you want to be heard on release conditions?
I do, Your Honor. And, Your Honor, normally I don't come and litigate the facts. There's a couple things that I wanted to bring to the court's attention to make sure that you are aware of everything before the release conditions are set. And I did see the states, and I tried to talk to Mr. Garcia beforehand to make sure he was aware of this information as well, to see if he would be willing to change it. He didn't mention to me that he wasn't making an appearance. Judge, when I read the Form 4, there is the statement from the alleged victim in this matter that he did throw a dumbbell and did strike my client in the head, knocking her unconscious with some severe lacerations, causing her to bleed profusely from her head, and then went out to contact police and have them come and deal with the situation. She was then rushed to the hospital. I did go to the hospital shortly after she was taken there. She does have some significant damage to her head. There's some staples that I can see here, Judge, which is consistent with the Form 4. But there's some other things that aren't consistent with the Form 4 that cause concern. She does have a broken arm from this incident. She does have internal bleeding from this incident. She's got bruising in several places in her body. She also does have a spine issue in the back. These are things that would not necessarily, I'm not a doctor, but these are things that would not necessarily occur from just being struck in the head with a dumbbell. And so it's deeply concerning that these are things that aren't mentioned from the victim in this matter. I also, Judge, that I have two children that weren't mentioned in the Form 4, two of the younger children, Melody Bearden as well as Harmony Bearden, that both explain from video conferencing that I've heard, both explain that she did not have a knife, that what she had in her hand was a cell phone. I also have information and statements from Keenan Cutright, who is her current boyfriend, who was on the phone with her, and he heard things from after she was knocked unconscious on the floor, individual stating put a knife in her hand. It was a kitchen knife that belongs to the house, so I find it weird that she has the kitchen knife from the kitchen in her possession or near her when this whole thing goes down, yet she doesn't get any further than the front doors. I'm asking the court to take all this into consideration. We're going to litigate this as we go through, but as far as release conditions are concerned, she's got some severe medical things that are going on. You can see the neck brace here. The spine issue is concerning. The damage to her head, she's got, I can see about that long, about 3 inches, Judge, of staples here, and they're worried about traumatic brain injury that might have occurred because of this. So I'm asking the court to look at that and take that into consideration. I've been contacted by numerous family members that are one of them, her sister's here in the hallway outside observing. I don't know if she can hear us or not, but she's here to support her. They've got a place for her to stay. They're going to take care of her and all of her medical needs, Judge. We're asking the court to look at that. I think under these circumstances, pretrial services, if you want to do electronic monitoring, that's fine, but I don't think at this point that a bond would be warranted under those circumstances with everything that we have here, Judge.
Thank you, Mr. Nagley. Let me look at a couple of things here. Ruby, that's good to reprint. So Ms. Bearden, obviously I can see, and I received some information from the arresting agency about some of your injuries. I understand that you're going through quite a lot. I don't wish anybody to be in the amount of pain that it appears that you're in. But I do have to consider with the allegations against you currently, I have to take that in consideration along with some of your attorney's statements. When I'm setting release conditions, there's about 15 different factors according to law that I have to take in consideration. Some of them is what your attorney mentioned. Your lack of criminal history here is one thing I'm taking into consideration, the nature of the offenses. Also, the big thing that I'm going on is the danger to the community aspect versus the danger to the listed victim aspects today. I mean, obviously, you're not really in a big position to go out and commit crimes currently. I think you're in a medical position that I do not envy. But I do have to take in consideration the allegations we're weighing against you are pretty heavy today. We're not here to determine whether you actually did anything. We're here to talk about whether there was cause to arrest you, and I did find probable cause based on the allegations today. Well, your attorney will litigate, I'm sure, the validity of the charges that are against you, but what I need to make sure is that everybody is safe. What I'm going to do, given all of what I have reviewed in terms of what the arresting agency provided me on why you're here so much past your arrest, also kind of what your attorney has argued, I am going to release you today to the supervision of pretrial services with an ankle monitor. My main concern is that you and the listed victim in this case do not have contact. So as part of my orders, I am going to order that you not return to the scene of the alleged crime, which is my understanding that that's the alleged victim's residence. I'm ordering that you not have any contact with any alleged victim, complainant, or witness, no possessing any weapons, no drugs without a valid prescription, no possessing or consuming any alcohol, and no driving without a valid driver's license. I'm also going to order that you must obey any terms of any order of protection or order against harassment that has been or will be issued. As of right now, I don't know if you have a custody arrangement made up with this person, but no direct contact between you and this person until further order of the court. If you have to go through other people to make custody arrangements, you'll have to go through other people, but no direct contact between you and the listed victim. Do you understand what my orders are today? Yes. Okay. Mr. Nagley, did you want to be heard on anything?
Judge, that was going to be my next request, was that third-party contact be okay, because they do have kids in common.
Yeah, I'm not restricting indirect contact right now because of that custody arrangement. I do see that there's an open family court case, so I don't want to restrict contact between her and her kids, obviously, but just no direct contact. Okay. Also, Mr. Nagley, as you're aware, and I think you already made a reference to it, she was brought to court considerably after the 24-hour requirement. I was provided with an order that was signed by another commissioner. Where did that go? There it is. It was signed by another commissioner on the 31st, yesterday at 12:07. Given a description of that your client was in the hospital, that she had not yet been medically discharged, so the arresting agency was requesting extraordinary circumstances to go beyond the 24 hours. It is my understanding that I received an update today that she was brought here pretty promptly after discharge, and I think she may be going back to the hospital.
I think so, Judge, and even if the time constraints were that they were, I would be arguing that you have to release her. You're doing that, so I think we're okay.
So I am making extraordinary circumstances findings pursuant to State v. Brown that it was good cause to go past the 24-hour mark. So if that needs to be brought up, of course, Mr. Nagley, you can argue that in the future, but I am making those findings today. I do believe that does address everything that we needed to do today. Mr. Nagley, did you want to be heard on anything else?
Judge, you did mention one thing, that no contact with any alleged witnesses. I think two of the older children may be witnesses, and that you're precluding contact with those two. Is that, we can talk to the assigned judge later on about that. I just want to make sure so she's aware of what she can and can't do, and I can inform the family.
Well, let me take a look here. So I believe the younger child was allegedly there too. Give me 1 second.
And in other circumstances, I would ask that if she's allowed to have contact with her kids, that the ruling be that she can have contact with them, but not to discuss the nature of the...
Yeah, I'll amend my previous order. I will say that she's not to initiate any contact with any alleged complainant or witness in regards to the facts in this case.
Thank you, Your Honor.
So let me get that modified real quick.
Have you heard that she's being taken back to the hospital, or you don't know? Do you know anything?
The only thing that we knew is that obviously if she was staying, she was going to go to our form of a hospital inside of the jail.
Okay.
But since she's not, that's something that she could, we can talk to the provider about requesting if she wanted to get transported or if somebody's here to pick her up to take her.
Well, she's got to see pretrial. I don't know what time pretrial.
Will be time morning.
They won't.
Well, yeah.
In the morning, right?
I'm working on having my officer give them a call and see if somebody's here or if somebody can come after hours. It's not a movie like 10 in the morning.
Okay.
So I'm trying to work on that so she's not here for another 16 hours. But I can't make any guarantees, but my officer's working on it.
Yeah, normally I just don't do it. I just want to make sure that she has, because of the condition she's in, if she's getting released here, that she knows that she has somebody to pick her up, like, right away. And then
I can also put especially because of the conditions, I can also put that phone number in the comments of her booking.
Please.
So that when she is on her way to get released, close, then we can get that person to call and make sure somebody's here to pick her up.
Perfect, you are on.
Yeah.
All right, this is Nancy Baca.
That's the one who's going to come to pick her up?
Yeah, that's the one that
we can coordinate.
Either we'll pick her up or coordinate. Just make sure 471-3024. That's old. Okay.
And then that one's simple too.
Yeah. No, write this on here.
Is that Baca?
Baca, yes. 471-3024.
I'll also see if what she wants is wanting to go back to the hospital to the provider is willing to. If she doesn't get released tonight, that we do what's called the release window.
Okay.
I don't know if they will do that, but we can. The provider calls tonight is pretty good.
All right.
Yeah, I'm okay with her.
Okay. And that's going to be all in the hearing today, Mr. Nagley, unless you have anything else you want.
No, Your Honor, sorry.
No, you're fine. You're fine.
We're
Coordinating it, that's fine. I have no problem with that. So, Ms. Bearden, all of your paperwork will be provided to you. It has everything that we reviewed with today. Your attorney will get a copy as well, okay? All right. And Mr. Nagley, if you want to go ahead and use that back room to talk with her for another moment, feel free. If not,
that's fine. I just want to ask real quick. Are you going to the hospital? Do you know what you want?
Wherever my sister wants to take me, I am in pain though.
Okay. He's got a phone number, so they're going to let her. They're going to let Nancy know what's going on.
That's her sister.
Yeah.
Yeah.
Okay. All right. I'm going to go talk to her. She's outside. Okay. Hang on.
Could you, since he's heading out, are you taking him out?
Well, I never take him.
Okay.
What do you want me to do?
Well, I was going to go try to sneak around to pretrial and talk to them real quick, see if somebody was here, send a call. So if not, I can just run her back real quick and then do that. That's fine. I got it. It's more second.
thank you, Counsel.
Thank you. I appreciate it.
That does conclude the 5 p.m. calendar. We will stand in recess until 8 p.m.